Good afternoon. This is the Maryland Insurance Administration's special public hearing on the proposed rate increase filed by Jessica K. Altman as Rehabilitator of the Senior Health Insurance Company of Pennsylvania, referred to as SHIP, on December 3rd, 2021. The proposal seeks to increase rates on long-term care policies issued in Maryland. The requested increases range from 0% to 1,361%, depending upon the policy form and other factors such as issue age, maximum daily benefit, benefit period, elimination period, inflation option, reimbursement methods, etc. By way of background, SHIP is a life and health insurance company domiciled in the Commonwealth of Pennsylvania that administers a closed block of long-term care insurance policies issued in over 40 states. SHIP is insolvent, and according to the Rehabilitator, its current deficit is approximately $1.2 billion. On January 23rd, 2020, the Pennsylvania Insurance Department filed an application to place SHIP into rehabilitation in the Commonwealth Court of Pennsylvania. The application was granted, and an order of rehabilitation was entered on January 29, 2020. The Rehabilitator's second amended rehabilitation plan, which we'll refer to as the plan, was filed on May 3rd, 2021, and approved by the Commonwealth Court of Pennsylvania by order dated August 24th, 2021, which was amended on November 4th, 2021. Maryland is not a party to the Pennsylvania rehabilitation proceedings, although we did submit formal comments in those proceedings. 3 states, Massachusetts, Maine, and Washington, intervened in the Pennsylvania proceedings, and those states have appealed the order approving the plan. The plan authorizes the Rehabilitator to alter the terms and conditions of the SHIP policies, including changing rates, without the authorization of state regulators, as is mandated by the law of each state in which the SHIP policies were sold. The plan does contain a, quote, opt-out, unquote, process. Under this process, a state can elect to opt out of the Rehabilitator's rating plan. In that event, the Rehabilitator would make a rate filing in the state. If, however, an opt-out state does not approve the rate demanded, the plan authorizes the Rehabilitator to alter the policy terms and downgrade benefits without authorization from the state's insurance regulator. I submitted an opt-out notice on November 15th, 2021. The notice states that it was being submitted in protest and in order to prevent the rehabilitation staff from taking the position that Maryland had failed to preserve the options that are set forth in the plan. The notice also indicated that the state of Maryland and the MIA reserve all of their objections to the plan, to jurisdiction, and to all of our rights, remedies, and options. The letter also states that SHIP must file its rates and forms, as well as any proposed adjustment in benefits to address approved rates with the administration for prior review and potential approval. As I mentioned earlier, SHIP did make a rate filing on December 3rd, 2021. Today's proceeding is a quasi-legislative hearing on that filing. The purpose of the hearing is to allow the Rehabilitator to explain the reasons for the rate increases, to explain the new benefit options, and to gather information that the MIA will use in considering whether to approve the proposed rate increase, whether it's in compliance with Maryland laws and regulations relating to long-term care insurance. To the extent that third parties have signed up, and I don't think any have, to the extent that third parties wish to be heard, as time permits at the end of the presentation by the Rehabilitator and questioning of the Rehabilitator and its witnesses by the Maryland Insurance Administration staff, we will allow people to make statements. That does not include the right to ask questions. Only the Maryland Insurance Administration and its personnel will be asking questions of the Rehabilitator and his team. But we will allow people who wish to make a statement to do so. I will just briefly introduce the members of the MIA staff who are here with me today. We have Brad Boban, who is our Chief Actuary. David Cooney, the Associate Commissioner for Life and Health. Van Dorsey, the Principal Counsel for the Insurance Administration, Adam Zimmerman, Senior Actuary, Jeff G., Senior Actuary, and our Director of Communications, Craig I., is with us as well. So as we get started, let me give SHIP and its team the opportunity to introduce themselves.
Thank you, Commissioner Bahrain, and thank you, MIA team. I am Patrick Antillo, the Special Deputy Rehabilitator for SHIP. And with me today are Ginger Darrow, who is SHIP's Chief Financial Officer, Allison Moore, SHIP's Data Analytics Manager, Dustin Plotkin, who is a principal in Oliver Wyman's Actuarial Consulting Practice, and Gabriel Albuquerque, who is the manager in the same practice. And if it pleases the Commissioner, I will make some brief introductory remarks to set the stage, and then our team is happy to answer whatever questions you and your team may have.
Thank you. I would appreciate that, Mr. Quintero.
So let me provide with just a brief, begin with just a brief historical note. SHIP is a pretty old company. It was born in 1887 as the Home Beneficial Society and began selling long-term care insurance a little bit less than a century later. Shortly after which, in 1996, it became part of Conseco and was renamed Conseco Senior Health Insurance. Then in 2003, it ceased writing new policies anywhere, including in Maryland. But by that time, the companies that had merged into it had issued about 645,000 long-term care insurance policies. In 2006, under an arrangement with the Pennsylvania Insurance Department, SHIP also assumed a block of LTC business from Teachers Life Insurance Company. In 2008, SHIP was spun off by Conseco and made an independent company, Senior Health Insurance Company of Pennsylvania, the affairs of which were overseen under an arrangement with the Pennsylvania Insurance Department by the Senior Healthcare Oversight Trust, comprised of 4 former chief insurance regulators from several states and a consulting actuary. In 2017, the Pennsylvania Insurance Department became deeply concerned about SHIP's financial condition. At the time, it was reporting a surplus of $28 million, which represented a half or 50% decrease over the prior year. The department began an intense analysis. By the next year, SHIP reported another 50% decrease to about $13 million in surplus. And then with the involvement of the department and its consultants, SHIP restated some of its actuarial and other assumptions and reported a deficit in March of 2019 for the year ending in 2018 of $467 million. As of today, we think that that deficit, as the Commissioner noted, has declined to about $1.2 billion. And that number fluctuates depending on changes in the capital markets and a variety of other factors. Not unlike other long-term care insurance companies in the market, SHIP has faced several problems that have led to these declines. For one, like many of its brethren, it has faced a prolonged period of suppressed yields on its invested assets, as the broader capital markets have experienced. There have been changes in the delivery of healthcare and the incidence of morbidity and the longevity of morbidity. And there have been reductions over what was originally projected in terminations, both voluntary lapses and morbidity and mortality. Probably the biggest contributor to SHIP's problem was its rate inadequacy, beginning with inadequate rates when the products were first sold because of inadequate assumptions, some of which, as I said, are industry-wide, but compounded over time with difficulty in requesting and obtaining rate increases around the country. And that has created 2 overriding problems. One is the deficit, and the other is a wide variance among the rates paid by similar policyholders for similar coverage around the country. That is an issue that is familiar to the Commissioner because it has been much debated at the NAIC as a so-called rate subsidization issue. By the time that the condition of the company was recognized to be what it is, Commissioner Altman, Jessica Altman, the Pennsylvania Insurance Commissioner, had put together a team of consultants and experts to both analyze SHIP's financial condition and evaluate alternatives for dealing with it. In due course, that team proposed a rehabilitation plan, which was communicated widely to state insurance regulators around the country even before it was filed with the Commonwealth Court. Eventually, the plan was filed in April of 2020. It was amended twice after that filing, and a hearing on that plan was held by the Commonwealth Court in Pennsylvania in May 2021. And after extensive briefing by the parties in August, the court approved the plan. And then in November, the court entered an order amending the approval, but making primarily stylistic and typographical changes, no substantive changes. That approval was then appealed by the interveners to whom the commissioner referred earlier, the chief insurance regulators of Maine, Massachusetts, and Washington, who had sought a stay of the approval order both in the Commonwealth Court and in the Pennsylvania Supreme Court. That both courts rejected that request, the most recently on January 31st by the Pennsylvania Supreme Court. So the plan has been in implementation beginning shortly after the approval. I'll make a little bit of this comment about the decision to rehabilitate instead of liquidate, because that's obviously a subject of much interest to regulators around the country. Commissioner Altman, when first faced with the financial problems faced by SHIP, as I think would have been most regulators, was inclined to simply place SHIP in liquidation. But she asked her team of experts to evaluate the alternatives. And after extensive analysis, for reasons I'll explain in more detail in a few minutes, they concluded that a rehabilitation plan would be better for policyholders around the country than simply putting SHIP in liquidation. That led to the creation of the plan that was approved by the court and which has been explained to regulators and policyholders around the country in a series of more than a dozen in-person meetings and many more telephone calls, as well as a wealth of information provided on a special website, a secure data site available to all insurance regulators. The key elements of the plan that have led the commissioner to select this plan rather than liquidation are that it does not truncate policyholder benefits to the guarantee association limits around the country, as would be the case in liquidation, that it does offer policyholders an array of meaningful options from among which each policyholder can select the one best suited to his or her circumstances, that it puts all of the policyholders on a level playing field in the sense that they will pay roughly the same premium for the same kind of coverage if they're in similar circumstances, and that it eliminates prospectively the rate inadequacy that has typified these coverages from inception and which have led to the subsidization problem. It does offer every policyholder at least one and sometimes more than one option that preserves their full guarantee association coverage if they elect to do that. It also enables every policyholder, if they are willing and able to pay for that, to preserve their full coverage, even if it exceeds guarantee association limits. The plan operates in principally 3 stages. Stage 1, which we call phase 1, is the one in which we're in right now and is by far the most important. In that phase, we will right-size the policies by resetting the premium on an if new basis, which is a premium rate which, had it been charged from inception, would have produced a 60% lifetime loss ratio. So policyholders whose current premium are above if new premium need not make any changes. They don't need to increase their rates or reduce their benefits, but they are given the option to do that if they find that one of the other plan options is preferable for them. And as I will discuss in a few minutes, a material number of policyholders have already availed themselves of that opportunity. That, of course, would not have been possible in liquidation. It is possible that after phase one, the deficit will remain, or some portion of the deficit will remain, and it may be possible that we will want to implement phase two of the plan. Whether or not there will be a phase two and what form it will take remains to be determined and will be subject to a further hearing before the Commonwealth Court in Harrisburg. But we did provide in the filed plan our current thinking of what that might look like. And it would be very similar to phase one, except that the rate methodology, instead of being if new, would be the self-sustaining methodology that may be familiar to some of you from the rehabilitation plan we had proposed for the Penn Treaty rehabilitation some years ago. Again, that all is somewhat up in the air and remains to be seen depending on the outcome of phase one and what the Commonwealth Court will decide, and of course what the Pennsylvania Supreme Court will decide. And then finally, there would be a phase three in which if assets remain, we would begin making payments to general creditors and wind down the company. I will spend just a minute describing the options available to policyholders, but I will pause before I do that in case there are any questions about what I have addressed so far.
Mr. Cantillo, I'm confident that there will be, but what I would just ask you to do is go through your remarks and any introductions you want to make or remarks from your team. And then, we'll start with the members of our team and their questions, because I'm sure they'll touch on those things among others.
All right, thank you, Commissioner Ray. We'll do that then. So policyholders whose states have not opted out of the plan rate modification sections, what we call opt-in policyholders, which currently would not include Maryland policyholders, will have 5 options. Option 1 is to keep their current premium and have the benefits of their policies downgraded to what could be funded by the current premium if calculated on an if new basis. Option 2 is to select a set of endorsements that we have created under the plan that we call the basic policy endorsements, which provide essential long-term care coverage, but at moderate rates. Option 2A, not a very creative name, I concede, is a slight variation on option 2 that provides a bit of a longer benefit period and a little bit longer inflation. So the basic option is 4-year benefit period and 1.5% inflation. The enhanced option 2A provides 5 years of benefit and 2% inflation. Option 3, again, a new creation under our plan, is what we call an enhanced NFO or non-forfeiture option, sometimes called a reduced paid up policy. And it provides up to 2.5 years of coverage. It's 2.5 unless the policy already has a lower benefit period and no more premium. As I'll explain in a few minutes, that has proven to be very popular among policyholders. And the most popular, unsurprisingly, option under the plan is option 4, which allows policyholders to pay the if new premium for their current policy and retain the full benefit of their policy. For opt-out policyholders, those whose policies were issued in states that have elected to opt out of the rate setting methodology, i.e. Maryland, the options are slightly different. There are 4 options. Option A is the same as option 1 for opt-in policyholders. That is, they can keep their current premium, but have the policy downgraded to what that premium funds. Option B, which only applies to opt-out policyholders, is to accept the rates approved by Commissioner Bahrain, whatever they may be, and have the policy downgraded to those rates. So the difference between A and B is option A allows them to avoid any rate increase. Option B allows them to approve the rates approved by the commissioner. Option C is a standard non-forfeiture option, which, as you probably know, in most places means the difference between aggregate premium paid in less the sum of premium returned and claims paid under the policy. Typically, as the commissioner probably knows, that provides at most a few months of coverage. And then the final option, option D, is the same as option 4 for opt-in policyholders. That's a voluntary ability to pay the full rate increase to preserve their current coverage. If a state like the Maryland Insurance Administration determines in response to the opt-out rate increase request that we filed to approve the full rate increase, then Maryland would be treated as an opt-in state, and the policies issued in Maryland would be given the 5 options of opt-in policyholders. I will give the commissioner and the team a brief timeline just to put things in context, and then I'll make a couple of closing remarks. We filed the plan, as I said, on April 22nd, 2020. It was first amended on October 21st in response to some suggestions about the treatment of reinsurance assumed and the inclusion of the issue state opt-out provision that we have talked about. It was amended again in May 2021, primarily to clean up some technical issues. And then it was presented to the court at a hearing that took a week beginning on May 17, 2021. It was approved, as I said earlier, on August 24th, 2021. And not long after that, there was an appeal filed. That appeal is pending. As part of that appeal, a request was made to the Supreme Court of Pennsylvania that it suspend implementation of the plan pending the appeal. Eventually, on January 31st, the Supreme Court denied that request. So the court has authorized, and we are continuing to implement the plan. We began distribution of opt-in elections to the policyholders whose policies were issued in states that had not opted out in January, and have received back about 20% so far responses to the ones that we sent out. What is remarkable about the elections we have received so far is that about 60% of the policyholders who have responded have made elections of options that would not have been available in liquidation. Those include options 2, 2A, 3, and option 4 with benefits in excess of guarantee association limits. The modifications of the policies for opt-in policyholders will commence sometime in April, unless, of course, one of the courts, the Commonwealth Court or the Supreme Court, rules otherwise. Packages for election to opt-out policyholders will be sent a bit later after we receive the rate increase decisions by the various opt-out states and are able to process those. So that may be sometime in May or June that we will send out the election packages to those policyholders. A total of 12 states had opted out of the plan's rate increase provisions. I'm not able to disclose which they are yet. We will eventually, but some have already opted back in, and we have been told informally by others that they will also do so. So I cannot tell the commissioner today, at the end of the day, how many policyholders will be in opt-out states. We expect that to be a pretty small number based on the information we have so far. We have filed with the administration a rate increase request that affects 393 out of the 901 policies issued in Maryland. And as the commissioner and the team knows, those rate increase requests were all based individually on a seriatim basis on the if new premium for each of those policies. As I noted, if the department, the administration approves that request in full, then those policyholders will be treated as opt-in policyholders and have those 5 options I described earlier. And if the administration makes any different decision, then they will have the other 4 options that I've described for opt-out policyholders. If we do not receive a decision by February 15, we have no discretion under the approval order to extend that deadline, so the application would be deemed denied in its entirety. I will emphasize as a closing remark that we have spent a lot of time evaluating the various options, and we think that from a policyholder perspective, approval of the requested rates in full provides the best result for the policyholders. I recognize readily that from the perspective of an insurance commissioner's ability to make his or her own rate determinations, opting out maximizes that possibility. And with that, Commissioner, we have available several people on the phone, as I said, that can answer the administration's questions, and I am happy to do that myself.
So I actually have two quick questions, maybe more, one of which is maybe more vocabulary for some of the folks who are participating or in the audience that may not understand. And then I'm going to ask our Chief Actuary, Mr. Broban, to lead the MIA's team in questions. But the first question I'd like you to answer is when you say if new, you're using KNEW, not NEW. And if you could define, what does that mean? What is an if new methodology? What does that mean?
Certainly, you're correct in noting the correct spelling. And what we mean by if new, Commissioner, is a rate that if it had been charged by the company from inception of the policy, based on what we know now about the liability, would have produced a lifetime loss ratio of 60%.
So in other words, if you had had a crystal ball back at the time that the policy was initially rated, and you knew all of the experience that was going to occur over the next several decades, what would you have charged back then in order to get to a 60% loss ratio? Is that it?
Exactly.
Okay. And the second question that I had for you is, why did you utilize a 60% loss ratio?
That's the most common adopted by states around the country. That some states have an either or choice of 60%, or some companies suggested a higher rate. We thought administratively using 60% would be simpler. Actually, all of our policies are pre-rate stabilization policies. So the alternatives used in post-rate stabilization rates would not be applicable to the SHIP policy.
So a 60% loss ratio roughly means that for $1 of premium taken in, 60% is paid out.
In benefits, yes, Commissioner, that's exactly.
And for an active company that is is actually writing new policies and isn't in essentially wind up mode, what does that other 40% represent?
Well, assuming a company is fortunate enough to meet that target, it would go to contingencies, profits, and unallocated loss adjustment expenses, or G&A, general and administrative expenses.
But SHIP,
of course. I hasten to add, Commissioner Brain, that although I frequently pretend otherwise, I'm not an actuary. There are very smart actuaries on our team who are cringing at my responses, and I welcome them stepping in to get us back on the proper track if I step off the rails.
Well, that's okay. I'll let my actuarial team take over the questioning, because I also am not an actuary and shouldn't pretend to be one. But I was curious as to why the 60% loss ratio under these circumstances, given SHIP's kind of general condition, the fact that it's in windup, et cetera. But I'll turn this over to Mr. Broban to lead the MIA team questioning.
Yeah, but may I make one more clarifying comment, Commissioner? Our rate methodology is prospective only, which is to say it makes no effort to recoup losses because of past inadequate premium or anything else. So even if we were to charge every one of our current policyholders a rate that produces a 60% loss ratio, that will not actually be the lifetime loss ratio for those policies because of the decades of past history.
Thank you, Commissioner. I guess I will ask a related question to that. Can you confirm that your self-sustaining premium estimates do not price to a 60%? Do not, assume that you're going to recoup the originally priced for profit margin, but prices to break even to actually cover claims costs and admin costs. Is that an accurate description of how those self-sustaining premiums are being calculated?
Right, the self-sustaining premium calculation is pretty mechanical. It would only apply, of course, to the small subset of policyholders who might be affected by phase two if it were implemented as described in the plan. And I'll clarify in a second that the policyholders would not be included in that category. But to the extent that it applies, it takes the projection of future benefits and expenses, the GPR for that policy, subtracts from that the projected premium from that for that policy, and the portion of the company's assets allocated to that policy. So it's a pretty simplistic calculation designed to make each policy self-sustaining, as the term implies, by making that policy pay for itself for the remainder of its longevity. It does not look at the company's history other than to the extent that that drives the portion of assets available to that policy.
You know, I just want to make it completely clear that that will not achieve a 60% loss ratio.
Absolutely. It will be a different loss ratio for each policy. And we don't look at, for that portion of phase two, we would not look at loss ratios. We would look at the gap. That, by the way, would, assuming that phase two were implemented the way we contemplate in the filed plan, there are several categories of policyholders that would not be included. First, any policyholder who is already at self-sustaining premium would not face any additional modifications. So, and that will happen. There will be policyholders who, because of the phase one, if new rate increases, will coincidentally already have self-sustaining policies. In fact, as we sit here today, about a third of our policyholders don't even require if new premium calculations because they already have rates at or above if new premium. Second, any policyholder who at the time phase two is implemented has a liability that would be fully covered by the applicable guarantee association, which, as we know, is $300,000 in most states, would be excluded from phase two. Third, any policyholder who in phase one elected option 2, option 2A, or option 3 would also be excluded from phase two. So the way we anticipate, and of course this is crystal balling, but the way we anticipate, if there were a phase two as described in our plan, it probably would only cover the richest of our policies who had insisted in phase one and continuing to retain the rich benefits.
All right, thank you for that clarification. I'd like to step back and ask some more broad questions about phase one. My first question is that the actuarial certification states that this rate filing is being requested in accordance with and subject to the terms of the plan, compliance with the applicable requirements of the 2017 NAIC model regulations, and applicable laws and regulations in your state were not considered in preparing this rate submission. I would just like you to comment on how it was decided by, that the plan would not have to take NAIC model regulations and state laws and regulations into account.
The hallmark of the plan is to have a uniform rate methodology for all of the affected policyholders, regardless of state of issue or state of residence. If we had attempted to make our rate methodology comply with the requirements of each of the states in which policies were issued, that would not have been possible because, as you know, different states have different requirements and criteria for the pricing of LTC products. Gabriel, anything you, or Dustin, anything you should add to that?
Nope, nothing to add, unless there's specific questions.
No, I guess that leads to my second question. Consistency across states notwithstanding, this seriatim rate filing is very unusual. A typical long-term care rate filing would implement, a flat increase across a whole set of policy forms, or divide the policy form into a small number of rating classes, such as limited versus unlimited benefits, or inflation rider versus no inflation rider, and give a flat increase across all policyholders. Can you comment on why the seriatim approach was pursued rather than a more typical approach?
Absolutely. When we started the process of evaluating and then designing the plan, we realized immediately that developing a seriatim model would enable us to focus on each policyholder's individual circumstances much more accurately than in the traditional cohort basis. The rate methodology adopts the same principle, which is we want the rate to be fair policyholder to policyholder. And even with the best of intention and the most precise division of a cohort, we still, in a cohort methodology, would always have had some policyholders subsidizing other policyholders, which is among the things that the commissioner wanted the plan to resolve. So in a nutshell, we think the seriatim approach maximizes policyholder fairness by having each policyholder charged the same dollar per pound of insurance, regardless of state of issue or state of residence.
Just for clarification, when you said commissioner in that answer, you are referring to the Rehabilitator, Commissioner Altman of Pennsylvania.
Correct. Thank you, Commissioner Wright.
All right, thank you very much for that response. An additional question I have is that our records show that all of the policy forms under review right now currently have unisex rates filed and approved. And from our correspondence via SURF and the actual memorandum, our understanding is that these rates are using gender as a rating factor, and the seriatim rates vary by gender. Can you comment on why it was decided that it was appropriate to add gender as a rating factor when right now two similar situated individuals of different genders would pay the same premium for the same policy? Why has it been decided to gender rate these seriatim rate requests?
Dustin, why don't I let you take the first stab at that?
Sure. So that's a good question. And the reason is a risk-based calculation. So the if new premiums are calculated based on our actuarial assumptions, our best estimate actuarial assumptions. And it's common practice to set actuarial assumptions for long-term care insurance based on a range of potential variables that would determine the likelihood or the amount of long-term care benefits an individual might use. And our actuarial experience study is a credible study. We looked at the past 8 or 9 years of SHIP's experience, and it demonstrates that there is a material difference in how a female uses their long-term care benefits versus how a male uses their long-term benefits. And so our actuarial assumptions were bifurcated as such, and also used as part of our if new premium. Those are the assumptions associated with our if new premium rating methodology. And just one other comment, if you look at industry actuarial tables, mortality, or intercompany studies, you'll often see gender as a variable in terms of risk for long-term care and other types of insurance products.
Thank you. And as a follow-up with that, you'll agree that it's accurate to say that you can use gender in your projections to make the most accurate, best projections without then using gender as a rating factor, and that other long-term care policies we reviewed, they may be using gender to make a best estimate projection for the pool, but then you can still collapse that gendered projection down to a unisex rate action, correct?
Yeah, absolutely. There are many assumptions that we make that could have been disregarded in the actual rate setting portion of the program. So you first project the total liability, and then you try to set premiums that will fund that total liability. And you can make assumptions that erode the ability of that premium to be more accurate on a policyholder by policyholder basis, for example, by making it gender neutral. But as I said earlier, a big hallmark of this plan is to try to compensate prospectively for the historical subsidization of some policyholders by others, inadvertently and unknowingly and involuntarily in most cases. And to a small degree, gender neutrality does that as well. Gender neutrality will necessarily have male policyholders subsidize female policyholders. For SHIP, that's about a 2-to-1 ratio. We have about 2/3 of our policyholders are male and 1/3 are female. I'm sorry, the other way around. 2/3 are female and 1/3 are male. So it's not a trivial issue.
Can I ask one little clarifying question, just in case I'm not clear on this? When these policies were rated originally, gender was not a rating factor. Is that
Correct.
correct?
That's
So
correct.
your if new methodology includes not just going back and looking at what we know now versus what we knew then in connection with the rating factors you actually use, but adding new rating factors into the mix. Is that correct?
Well, I suppose that's a matter of definition. I think a lot of the assumptions underlying our rate methodology today differ from those that were made when the policies were first issued. And a lot of those differences are attributable to learned lessons in the ensuing decades. The degree to which gender neutrality would cause a substantial distinction in experience versus rating methodology probably is much larger today than had been predicted back when the policies were issued. But Dustin, you may want to add to all that.
That makes sense. And yeah, historically, when you think of an like old long-term care insurance business, it usually was issued on a unisex basis. But when you look at more of the recent business, that is not the case. You see more gender specific. So we're, in the as Patrick mentioned, based on lessons learned, we're doing the same thing in our if new premium calculation.
So I think that's a yes. It wasn't a factor when the policies were issued. It hasn't been a factor in any rate increase request up until now, but it is currently a new factor. You're using now gender for the first time to differentiate in rates between policyholders.
That's correct. And as you know, Commissioner, typically before the company was in rehabilitation, if it filed a rate increase application, it would have had to do that on the same basis on which the policy was originally rated. So if it was a unisex rated policy to begin with, it had to remain unisex in subsequent rate increase request. Well, the plan does not face that constraint. The hallmark of the plan, and I can see readily, I'm certainly not trying to argue with the proposition that we're using a factor we didn't use back then, or I shouldn't say we because I wasn't around, but that the company didn't use back then. We are really striving to be as precise, given the limitations that we face in setting a fair premium for each policy.
Can I follow up on that if I could, Mr. Cantillo? If I understand what you've just said, what is the difference between a company that's not in receivership, which can't do what we're trying to do, and is the plan itself? Is that what you're saying?
Yes. So Article 5, Mr. Dorsey, of the Pennsylvania insurance laws, which is the one that governs, among other things, rehabilitation and liquidation, authorizes the commissioner with court approval to restructure the company in any of an infinite number of ways. And that includes restructuring products and rates. So we believe, obviously that's a matter of, open to some discussion in the courts, but we believe that the constraints that would have governed a rate increase application for a company not in rehabilitation do not apply to SHIP in rehabilitation.
Irrespective of whether or not there are laws in the various states where you have to file those rates that would prohibit that?
That's our view. Our view is that it's the rehabilitation court, the domiciliary rehabilitation court, that sets those parameters.
I stole your time there, Brad. I'll go back to you. Thanks.
That's okay. This is a good discussion. Shifting to a different topic, to the benefit reduction options. The financial projections provided alongside the filing have shown that if the rate increases are approved in full and everybody pays the higher rate increase, that there is not a large step towards eliminating the deficit, and that benefit reductions are really a key component to significantly make a dent in the $1.2 billion deficit. Your testimony earlier said that of the opt-in states, that 60% of policyholders have chosen option 2, 2A, or 3. My question is, what is the rationale for not providing those popular buy-down options in opt-out states and providing opt-out policyholders with, objectively inferior options to options 2, 2A, and 3? It would seem to incent them to not take a benefit reduction and make the plan less likely to succeed. So what is the rationale for not providing the opt-out policyholders with those same 3 options, please?
Let me begin by making clear if I misspoke earlier, I apologize. What the results of the election so far has been: 60% of the policyholders who have made an election have elected option 4, not 2, 2A, and 3. 20% have elected option 3, the enhanced NFO, and the balance have elected options 1 or option 2. I can't promise you that as the remaining 80% of policyholders send in their elections, they will stay at those splits, but they have been pretty uniform so far. Although as we get more elections in, we see a slight trend to move away from option 4 toward options 2, 2A, and 3. The reason we are not offering options 2, 2A, or 3 to opt-out policyholders is because they are not based on an approved policy form. The hallmark of the issue state rate approval process is that we are not wholly ignoring the ability of each of the departments to weigh in. And if we were to impose a new policy form that had not been previously approved, we would be doing that. So the extent to which we are departing from the tradition of letting the issue state make all the decisions is simply to adjust benefits, to calibrate the cost of the benefits to the premium approved to avoid subsidies. But because options 2, 2A, and 3 are based on policy forms that have never been approved in, for example, Maryland, we're not offering those. Of course, Maryland could still make those available to its policyholders by approving the rates in full. No one has yet demonstrated to us why policyholders would be better off by not approving those rates in full.
Could I just jump in for a question? If your reasoning is that, well, the forms haven't been approved, you also haven't submitted the forms for approval. So you actually could do what Brad has suggested if you wanted to by submitting those forms for approval.
Maybe not, Commissioner Brain. I suspect that our options 2 and 2A would likely not be approvable in many jurisdictions because of the combination of premium and benefit. Even if that were not the case, the length of time required, as you know from your own experience, to submit those forms for approval and then going through the approval process would be beyond what is possible in order to make our plan feasible.
And are you suggesting that, so let's say for the sake of argument that we were to deny the approval, under the plan, what would then happen would be that you would adjust benefits accordingly. And so are you saying that you would adjust benefits accordingly, providing, however, all of the categories of benefits, and what you would just be doing is toggling the amounts? Because
So it depends on the individual circumstance, but for example, if you only approve part of our request and you had a policyholder who elected option B, that is to take the rate you approve, then using the algorithm that's described in the plan, we would reduce that policy's benefits to produce a cost on a new basis equal to the premium that you approved. And the plan describes the way in which the benefits are adjusted. There are 11 steps, I think actually 9 apply to opt-out states, but I don't have them memorized.
But you don't perceive that as a change in the form?
I think that's a metaphysical question. You could argue it either way.
Okay, all right.
Well, so another question related to that. You're essentially saying that benefit reductions do not have to be consistent with the rate table that's approved by the MIA?
Under the plan, that's correct. In fact, we state clearly in the plan that we're not adhering to rate tables.
And I have a couple of just factual questions, and I apologize, these are probably already in your documents, which my actuaries probably know, but it's useful for me to just hold it in my head as we're sitting here today. Can you remind me how many current policyholders there are nationally with SHIP?
I believe we have somewhere between 35 and 40,000 policies in force right now, of which a significant number are in NFO status or already have premium at or above FNU level. So the number of policyholders who will be asked to make an election is closer to 20,000.
Okay, and with respect, can you divide that up between those states that have formally opted out? Because I think, well, you know, it may be neither here nor there, but there's some states that just have ignored the opt-out, you know, completely. Like, for example, a state that may have actually objected and be appealing the plan may have chosen not to issue an opt-out notice because they don't recognize the validity of the plan. But I don't know whether you all, in sort of the work that you've done so far, have divided that population between what you would think of as opt-out or opt-in states. Do you have any metrics around that?
Sure. If all 12 of the states that sent an opt-out election remain as opt-outs, that would be something over 4,000 policies.
Okay. And then in terms of, you were sharing with us for those states that are opt-in states where notices have gone out, and you've begun to get notices back. Can you give me a sense of how many notices you've gotten back, percentage of, you know, whether a percentage basis of whatever the...
About 20%. If I'm understanding your question, we sent out opt-in election packages to all of the policies issued in states that had not opted out or which were not covered by the injunctions issued in South Carolina and Louisiana. And those injunctions only affect about 650 or 700 policies. So excluding those two groups, the opt-outs and the injunction states, we sent out about 20,000 election packages, and we've received about 20% of those back.
Okay.
And
All right.
there's about another month left to go before they have to make their final decision.
Okay, thank you. That's helpful.
I'll say that those were the primary rate questions I had. Jeff or Adam, do you have any additional rate related questions that you'd like to ask?
Yes, I do have. One question is that the right totally you only have 13 forms in Maryland, but in other states you have additional forms?
No, we are offering exactly the same 5 options in every state for opt-in policyholders and exactly the same 4 options in every state for opt-out policy.
No, I'm talking about forms.
Oh, do you mean the original forms? Sure. I don't have a complete count, but there are hundreds of policy forms that have been approved over the decades for SHIP and its predecessor companies. Some of them date back to the 80s and 90s. Some of them were more recent. None is more recent than 2003. But over that period of time, there's a wide variety among the approved policy forms around the country.
So this action only impact 13 forms nationwide?
Well, the impact of the plan is not based on the existing form. It's based on the comparison of the existing premium rate to the if new rate independent of what the underlying form looks like. So the plan does not look at the form itself to select adjustments to the policy.
Yeah, because I see one of your objection responses, only 80%. This 13 forms only about 80% your total ship in force. So it looks like there the other 20% related to other forms. I don't know what's going on for the other 20% in force policies.
Maybe I
Yeah,
can.
go ahead. I'm sorry, listen.
Yeah, Jeff, maybe I try to answer your question. So the 13 forms are, these are 13 forms where there are policies issued in the state of Maryland for which we are seeking a rate increase under this opt-out rate increase filing. There are, as Patrick mentioned, there are many more forms. Some of these forms might also have policies issued in other states as part of the opt-out process, but the 13,
Right.
the definition of the 13 are the 13 forms with policies issued in Maryland for which our rates are being, rate increases
that's
are
what I
being
want to
sought.
know. Okay.
And there are no other forms that were issued in Maryland that are not being impacted right now, right? This is all of the forms that were issued in Maryland are part of this increase.
I'm not
Yeah.
sure that's true. I think there may be some that had premium at or above if new rate that would not include it.
So if 100% of policyholders were at or above if new rate, they would not be included in either the memorandum documents or the supporting documents on the website.
Right. Remember that only about 390 of the 901 Maryland policies are within our rate increase application. So I can't tell you the remaining 500 or 600 how many have the 13 forms or a different form.
Gotcha. Okay. And then my second question is about original pricing assumption and the methods. Looks you do not have those information. I want to know why. Does that mean the company lost those information, or you think that's not necessarily to have because what your methods and assumptions are up to date? You don't have to use the original methods and assumptions.
Dustin, do you want to answer it?
Yeah, so Jeff, your statement is correct that our rate increase methodology does not have any anchoring or dependency on assumptions and methodologies set at original pricing. And Oliver Wyman and my team, when we were involved in the rate increase filing, we came involved a couple of years ago. We don't have access to all of the original pricing type information that you requested. That's the initial response Patrick got.
But if you talk with the ship, you might get some original pricing assumptions or methods, right? If you talk with the ship, but you think that's not necessary.
So we have, just to be clear, we have full access to the ship staff and whatever information exists in ship's files. But as you know from your own experience, we have to be judicious in how we expend our resources, and analyzing that history was not an element of the plan. And so asking Oliver Wyman, for example, to go back and analyze decades of history just for the purpose of knowing what happened, even if it's not relevant to the plan, didn't seem like a wise use of our money.
Okay. The reason we want to see, because we noticed you introduced the gender and also maybe policyholders' birth date. Those are new factors. We want to see additional factors you introduced now, because compared with 10 years ago, certainly lots of things changed. We noticed many companies started to use gender as a rating factor. So then we want to know any other factors or variables you introduced that's not very common 10 years ago. Can you discuss that?
Sure. Dustin, are there any other factors besides gender that we've added to the calculation?
Yeah, and also the birth date. Because I found one example I asked, there's a 2% gap for the for the same coverage, same variables, age, but you explained because they have different birth date. So that's the reason cost 2%, a really increased gap.
Yes, on the birthday comment, that's just fallout of no actuarial model is perfect. It's based on a discounting calculation, and it was a few dollars difference. It was a small difference. That is not a primary consideration in how the premium rates were set. There may be very small differences for that reason. If you look at our inventory of actuarial assumptions, it was a spreadsheet that I think it is available on the secure data site that will list all of the variables we use in our actuarial assumption. As for comparing and contrasting which actuarial assumptions we're using today versus what was used at original pricing, that's not something I have information to respond to.
Okay. Then my next question.
I'm sorry, just to clarify, so it's not something that you have information to respond to today, or it's not something that you could ever respond to?
So our secure data site inventories all of the assumptions we're using in the plan. What we haven't done is gone back policy by policy to identify the actuarial assumptions that were made when each of those policies was rated at inception. So we don't have the ability. It's not that just that we're not doing it. We don't have the ability without doing that to compare our current actuarial assumptions to the actuarial and assumptions used at issue for each of the different policies around the country.
Other than,
and I'm not really sure even if we tried that we could replicate all of the original actuarial assumptions. As you probably know, Commissioner, there's about a half a dozen companies that issued these policies, which were merged up through the Conseco channel before they became SHIP.
Yeah, it looks like maybe the first principle method you introduced, like the mortality, difference between disabled members versus the active members. Those may be might be not used before. So those could be a new variables too, right?
Yes, most certainly. That would likely be one difference where we have a distinction between an active life mortality assumption and a disabled life mortality assumption, which is common practice today.
Right. Okay. And then my next question is, we noticed that currently 393 members be impacted by this plan. So about 30% are males, the rest 70% are females. So it looks like skewed to the females. But so my question is, then there's 112, the other 112 members, they are not impacted. Does that mean, did you notice that the gender were more skewed to the male side?
I don't think so. I think that 70-30 split is pretty much uniform throughout the population, regardless of disability or active status or state of issue or inception.
So you are saying essentially you have more female policyholders than male policyholders.
Many more. I think the total ratio is 70-30 or 69-31, something like that altogether. That's not unusual, by the way. We saw the same kind of split at Penn Treaty.
Okay.
I want to make sure I understand. Are you saying that the rate increases don't skew higher for women than they do for men?
No, I was not addressing that at all. What I was addressing, Ben, was the gender split in our insured population. So of all our insureds, about 70% are female and 30% are male.
Okay.
And we had seen a pretty similar split at Penn Treaty. That's not unusual for legacy blocks. It differs for active blocks, which have obviously a much higher younger population than we do, for which the split is not as dramatic.
Have you
That's of course consistent with mortality tables.
Have you analyzed the difference in the increase between men and women?
Dustin, do you know that?
We have not performed that analysis.
Well, Mr. Plotkin, do you have before you the de-identified policy list For Maryland, do you have that?
Yep, I do.
I noted that with regard to the 100 people receiving the highest premium increases in this proposal, increases of between 250 and more than 1,300%. 93 of the 100 are women. Contrast that with those who are receiving the lowest amount of premium increase. The top 40 of them, more than half of them are men. And now my question for you is that's an indication, is it not, that the rate increase skews higher for women than it does for men?
Like I said, I haven't done that analysis. What you're saying is not a surprise to me, and largely driven by the initial unisex premium rating. However, if based on our experience study and based on what's commonly known in the industry from an actuarial perspective, that females tend to have a higher risk for a long-term care insurance product. And so if you're moving off a unisex rating to a gender distinct rating, it would not surprise me to see females with higher rate increases.
So you're creating a new subclass of women per policy form, essentially creating a new subclass of women in terms of using that as a rating factor, correct?
Well, we are using gender as a rating factor. I'm not sure, Mr. Dorsey, whether that creates a new subclass. That may be a legal question, not an actuarial question. It's not a separate risk class, if that's what you mean.
Well, isn't it? It's a risk factor that makes it.
It's a risk factor, definitely a risk factor.
Do you have the,
Go ahead, Brett.
no, I was just gonna ask, do you have the gender data for all policyholders in the seriatim rehabilitation options file? It contains 691 policyholders, those who have current premium greater than if new premium, and so are not getting an increase, and those who are on premium waiver, and that file right now lacks gender. Are you able to provide us a gender by for each of those
Right.
policyholders, so we can
Right.
see what the gender distribution is for those who don't
Not
need an
impacted.
increase?
I think there is another file on the secure data site that does have gender identified. Isn't there, Dustin?
I would expect so. So there would be a seriatim file that I think includes all, I don't know the exact count, 30,000, 25,000 policyholders, including those in Maryland, including the 600 that you mentioned. My understanding is that gender is there. If it's not for some reason, then it's certainly something that could be added, but I do believe it's there.
I seem to recall that it's in there, and you could just sort those for Maryland policies and then get the split that you're looking for.
All right, we'll have to do some more investigating. I mean, there's several seriatim files out there. The one that Jeff and I have been looking at does not have gender,
Right.
but we will see if we can cross-file things, but and find a seriatim file that does. And if not, we'll let you know and ask for that information.
Absolutely. So we tried to create one file that would replicate how the options would affect each policyholder. That was a pretty major undertaking, and I don't believe that one is gender sensitive. But there's a different file that is larger that has all of the key characteristics for the policyholders that does not project the results under each option, and I believe that one does have gender identification.
My guess would be more skewed to the male for non-impacted because of your introduce the gender there. So the impact to male would be smaller.
Yeah, I can't comment on that because I haven't looked. So.
Okay. Yeah, my another question, did I hear that right? So you price it at 60% and then loss ratio after you incorporate expense and the investment income, then you just end up break even. You don't have any profit margin. Is that right?
Well, in reality, we're gonna have a giant loss because it's not retrospective, it's only prospective. If we had actually charged that rate, which we did not, if we had actually charged that rate from inception through the current, then it probably would include some profit component, but we haven't actually charged that rate, right? We will only be charging it from now forward. By
Yeah,
now, we have giant accumulated losses that we will never recoup that way.
Yeah, we may interested to see lifetime impact, incorporate the history and the projection to
Yeah,
see.
if we had been able, I think the answer to your question, Jeff, is if we had been able to charge these rates from inception, they would include a component for profit and contingencies.
Okay, and then I try to see your expense assumption, and I see your investment income is interest like 3%, right? But
I'm afraid.
Yeah, expense, there's like commission expense. I don't know, your commission is information from the company, but the expense, that assumption file didn't mention where that source from. So anyway, those assumptions generated by you or also from SHIP for expense part?
They come mostly from SHIP, although we review them for reasonableness.
Okay.
And this
Then,
one,
I'm sorry, go ahead, Dustin, you were gonna add something?
I just want to clarify in the if new calculation, we're not applying an additional expense projection or expense assumption on top of the 60% loss ratio. So no additional expenses are accounted for in the rate increases being sought besides the 60% loss ratio. I just want to make sure that that's clear.
so you haven't looked at the net income scenario, lifetime net income. Are you saying you just look at the lifetime loss ratio 60%? Is that right, Dustin?
In determining, can you please restate the question? I want to make sure I understand.
My question is you just look at the lifetime loss ratio 60%. You haven't looked at the lifetime net income. Is that right? So you.
So the 60% loss ratio is if we were to reprice from the beginning. I'm not sure if I'm fully understanding. After applying these rates, the requested rates, assuming they're approved in full, the
Yeah.
lifetime loss ratio will remain well above 100%. I'm looking on my screen now. In the state of Maryland, it'd be about 115% a lifetime loss ratio without including interest, or if you were to include interest, that increases to 154.
That's
I
for
don't know.
future, right? Not lifetime, right?
I know
Yeah.
that is the lifetime loss ratio, assuming the if new rate increase is approved in full on a go forward basis from say 2022 onwards.
Yeah, 2022 onwards. That's the projection. You are
Yeah,
saying.
so he's
loss
combining their
ratio.
projected experience with the historic actuals to get that projected lifetime loss ratio.
Yeah, we want to see lifetime. Try to see, do you have some, profit margin there, lifetime, including history and the future.
You mean lifetime from inception?
Right. No, I
Jeff-
mean, lifetime is based on currently cutoff date. We want to see history. History would accumulate to currently. Future going to discount to currently. So add them up together. We want to see any profit margin. Is my question clear?
Right. So Jeff, as I said earlier, that the assumption of a 60% lifetime loss ratio from inception, which is the methodology we're using.
Yeah,
would-
that's just based
would-
on projected incur claims and earning premium, right? You haven't looked at the expense and also investment income, historical investment and future investment and historical expense and the future expense. You haven't looked at those yet. So we also would like to see a net income after incorporate, like the original pricing, you want to look at the expense and investment income too.
No, I think that, Dustin, didn't we take into account expenses and investment income in the lifetime loss ratio projection? When we set the 60% loss ratio.
Yeah, that's just loss ratio, but we want to see also net income, which means need to do more beyond just lifetime loss ratio. We want to see your running expense, your commission, and also your investment income based on reserves, and all kinds of reserves. Add them up So net income would be, you earning premiums minus, plus your investment income minus your claim payment minus your expense minus your commission minus your tax. That would be the income each year, and then you have those present value calculation, and you can show us the net income. So I think that's the follow what I'm saying, right?
So you mean prospectively though, right?
No, current present value.
That's
Present
right.
value.
Yeah.
Jeff, can we please talk about this offline? I think the answer to the question is that there is not profit being realized from this plan.
Absolutely not.
The company
It's a
still
time
remains in a
loss.
significant
Yeah,
deficit.
this method does not allow them to recover the past losses. So I know overall, but I mean, just based on this method, the if no method from very beginning, that kind of thing. Yeah, we can discuss after.
So I think your question, Jeff, if I'm understanding it, is assuming we were at break even today, that is that we had no deficit today, would these rates going forward produce a profit? Is that what you're asking?
No, just as the commissioner said, if you have if you know on the very first day, if you know everything, use the current best estimation, you do the pricing there. So what is your profit margin? That's what I want to know.
Okay, is that something we
If
can
you have a
determine?
crystal ball, maybe 20 years ago or 30 years ago, when you do the pricing, or okay, we should price in this way, use those assumptions from very beginning, right? You definitely need a profit margin there. We don't want to originally price at a loss.
So maybe what we would do to wrap this up is that offline Brad can get with Dustin and see if there's any additional information we want. I think what Jeff is talking about is applying sort of an if new approach on both sides of the balance sheet. But let's we can put our heads together to see if there's more data that we need.
That's a good idea, Commissioner.
That's all I have. So I don't know, Adam, do you have anything to ask, Adam?
I mean, the only question I would have, and I think this is more of a legal thing that maybe Van might touch on in a minute, is as an opt-out state, we have rate review authority to, or have elected to opt out so that we can review the rates and determine, what rate increase we believe is acceptable and adequate based on the current assumptions. But as part of the opt-out state, regardless of what we approve, if we approve, anything besides the full amount and become opt-in, one of the opt-out options is that you are going to still provide the consumer the option to pay the full rate increase, even if it has not been approved by the MIA. So as an example, if a consumer's projected under the if new methodology to receive a 200% rate increase, and whatever the ultimate decision is, the consumer is still going to be given the option to pay the 200% rate increase, even though it wasn't approved by the MIA. So I was just wondering if you could speak to that.
Absolutely. So I said when I started my remarks that we communicated extensively with regulators around the country about our proposal for the plan. When we described the original concept for the issue state rate approval, we did not have option D in it. That would not have been available. And several regulators commented that it looked like opting out would have punished their policyholders by depriving them of the ability to retain their full coverage if they were willing and able to pay for it. So we added option D exactly to respond to that criticism. We did not want the opt-out process to punish policyholders who could and would be able and desire to pay the full rate to retain their current coverage. This is, I'm sorry, I was going to say, this is one of those cases where you're going to make some people happy with whatever decision you make and some people unhappy, and it doesn't matter which of the two decisions you make. So But we
I-
thought
I-
on balance, giving that flexibility to policyholders is better.
So just to be clear, you're going to offer, if the full rate is not approved, you're going to offer, the if new premium rate that you propose to policyholders, despite the fact that it's not been approved by the commissioner and therefore is illegal under Maryland law. Correct?
Well, man, you and I can talk separately about whether or not it's legal, but factually, yes, we're going to offer each of the affected Maryland policyholders the ability to retain their full coverage by paying the full if new premium, even if that full if new premium has not been approved by the MIA.
So I have a
And-
question about policyholders who are on premium waiver. According to your seriatim options file, there are 102 policyholders who are on premium waiver but have current premiums lower than if new premiums. My understanding is that the only option they are going to be given is a benefit reduction. You've not filed for an increase for them, and that the only option they are going to have is a benefit reduction, and there's going to be no way for them to keep their current benefits. Is that an accurate description of what is going to happen to these members on policy waiver?
That's correct.
I guess I have a follow-up question of why that's the case. Why is it so important to give people that aren't on waiver a choice to keep their current benefits, but there's not a way for policyholders who are on waiver to keep their current benefits?
The short answer to that is we're not changing the premium structure for people who are on waiver because we received extensive comments from regulators during the process I described about if you're doing the opt-out, don't charge people on premium waiver more premium. And the only way to accomplish that goal is by calibrating the benefits to avoid having other policyholders subsidize them. We could have created a new option like we did with options 2 or 2A for the opt-ins, but it would have been a new policy form.
So you use that word subsidize. I like the word risk pooling because that's what insurance is. It's pooling money. So literally the concept of insurance is one policyholder subsidizing another policyholder. Because if everybody used up 100% of all of their benefits under any form of insurance, the company would be insolvent always. But when you say subsidize, you're really just talking about how you're dividing up the money that's in the pool. And what you guys have decided to do is to literally segment it down to the individual policyholder.
Well, what I believe we've done, Commissioner Bahrain, is to put all of the policyholders on a level playing field in the sense that they would each pay the same dollar amount for each pound of insurance, regardless of where they live and where they bought it. There would still be risk pooling, right? Because as we all know, for any group of 100 policyholders, we only expect a small percentage to ever present claims, and the premium paid by that small percentage would never fund those claims, right? Those claims would be funded by—
We're not talking about pound of coverage though, because if I am a female of a certain born on a certain date, so all of those, my pound costs more or less than Brad's pound. So it's not across the board, chicken is X number of dollars per pound and everybody's on the same plate. It's the amount per pound is then further refined by a whole set of characteristics, many of which were not rating factors to begin with, but which are drivers of risk.
I think your last comment is the most accurate one with respect to what we're doing. We are trying to calibrate the premium to the risk presented by each policy. And I make no bones about the fact that we're doing that using factors that were not used at inception. But we are doing the best we can with the data available to us now. So,
but very granularized to individuals, so that instead of sort of broad rating characteristics, by the combination of multiple factors, many of which are new, But by the combination of all of those various factors, these are very individualized, almost custom and personalized per policyholder.
Well, we apply them uniformly to all policyholders depending on the risk characteristics. So you are correct that the risk characteristics vary from policyholder to policyholder. And you're also correct that we're being more precise in identifying and making provision for those risk characteristics than is traditional. But I don't think we're inserting a new level of bias or discrimination based on the risk characteristics by doing that.
I just wonder about sort of how the the integrity of the size of by the time you get down to almost individual cells, how you are able to be so clear and certain from sort of an actuarial standpoint with down to those cells. But I will let my actuaries look at that and not try to pretend to be one here. I also think that Mr. Dorsey will get into some questions about, looking at kind of comparisons between individual policyholders and trying to understand, what those differentiations are.
Well,
I'll take that. I'll take
Yeah,
that as my cue.
go ahead, Vin. I'm done with my questions.
Well, along those lines, one of the factors that has changed is issue age. And can you, Mr. Cantillo, explain how that risk characteristic has changed from how it was used previously by SHIP?
Actually, I'll ask Mr. Plotkin to address it.
Okay, that's fine. Thank you.
So issue age, can you repeat the question?
Explain how the use of issue age has changed from how it was used by SHIP previously.
Okay, so issue age is an issue age that's constant, whether you look at the business today versus whether you look at when it was issued. So we're not changing if someone was issued at, say, age 65 20 years ago. When we set our rates today, they are still based on them being issued at age 65.
So
so far,
explain
so
to
good?
me then, my understanding is that you have changed it so that now it is more granular in that you look at issue age down to not just the year, but also down, the month that their month of their age at the time of the issue date. Is that correct?
There is a small amount of noise, and we're talking 1 to 2%, that is driven by the discount rate, the application of the 3-point-something% discount rate in our if new calculations, where you might see a minor difference depending on the date, but that is very, very minor. Otherwise, the specific date of issue does not have any meaningful impact on the rates being requested.
Well, okay. Well, let's look. At the de-identified policy count. Look at the last two on that list. The first one has an issue. They were both issued policies in 1990.
Okay.
One was 56, one was 57. Looks like they had the exact same policy form, same policy benefits.
Sorry to interrupt. The last two on my list were issued in 1998. Can you maybe provide me the ID numbers?
Yep. It is 1533284.
Okay, and the second one?
1491291.
Okay, I got them up. Please restate your question.
Sure. So same issue date almost.
Mhm.
Different, they're a year apart in age. Their premium difference increase is about 50%. Can you explain that?
So based on this file, the one key product feature difference that I'm observing is the maximum daily benefit. So the individual with the lower increase has a maximum daily benefit of $433. The individual with the higher rate increase has a maximum daily benefit of $519. So that would be the primary driver of the difference in rate increase being sought.
And how much of it would be the difference in age?
I don't have that number, but it shouldn't be it. If it's more than 1 or 2%, I'd be surprised, but I don't have that number.
Let me ask about the policyholder elections. Am I correct that the policyholder elections and those elections imposed by you would be deemed irrevocable even if the rehabilitation plan is overturned or otherwise modified on appeal?
No, I won't presume to speculate as to what a court might decide to do if there were a reversal on appeal. We have made clear that the policyholders elections would be reversible if there were a Supreme Court decision telling us to do that.
And it's also true that for policyholders that select policy downgrades or paid up policy options or that they could potentially face more rate increases during phase 2, correct?
Depending on the options, if they selected options 2, 2A, or 3, which are the basic policy in the NFO, they would not face additional rate increases. If they selected option 1 and option 4 and were fully covered by guarantee associations, they also would not be facing rate increases. And if they selected option 1 or option 4 and were already self-sustaining, they also would not be facing rate increases. So at the end of the day, the policyholders would be potentially exposed to additional rate increases if phase 2 were implemented as described in the plan, would be those who selected options 1 or 4, were not fully covered by guarantee associations, and were not already self-sustained.
Okay. You know, at the hearing on the rehabilitation plan, you testified that the success of the plan did not depend on large rate increases, and that you did not want to have sticker shock with regard to the rate increases. My question is, you know, what rate percentage to you constitutes sticker shock?
So I don't recall exactly what I testified at the hearing, but I do recall saying that rate increases would not solve the company's problem because the premium runway left for our insured population is relatively short because of the age of the population. So what would drive the success of the plan would be more the reduction of liability attributable to reductions in benefits than increases in revenue by increases in premium rates. I don't recall addressing at all what level of premium increase would be sticker shock, but there is no question that there will be policyholders who, if they elect option 4, will face rate increases that could be several times their current premium. Whether that's sticker shock, whether it's sticker shock or not is a subjective determination. I will tell you that we have already had a number of policyholders elect to pay premium many-fold their current premium in order to retain their current benefit. So I am assuming that for them, the benefit structure is worth the additional money.
Actually, what you said is at the hearing was that you couldn't seek rate increases, you know, in the thousands of %. But isn't that's exactly what you're doing in this case?
There could, so if you're asking me, are there policyholders who will face rate increases in the thousands of %? That's possible. Well, I just can't tell you, but bear in mind that when I said that, I was explaining that the plan options included a number of options to mitigate the rate increase required to attain if new premium. So it is certainly true that option 4 might result in that level of rate increase, but it is also true that the very same policyholders could avoid them by selecting one of the other options.
Well, I'm just
Mr.
looking at the
Pantia,
rate increase.
I'm sorry.
Go ahead, Commissioner.
I was just going to say that I hear you with regard to this round, but this is not necessarily the only round of rate increases that could occur.
Right, as I said, if the plan proceeds as described right now, in phase 2, the subset of policyholders who chose options 1 or 4 and who are not self-sustaining or fully covered could face additional rate increases. And those might be large. Again, even in that phase, though, they again will have the same options. So at that time, they will have another option to avoid any rate increase at all, or to not pay any premium at all going forward.
And you agree that
Is it not accurate to say that the seriatim approach leads to a wider variation in rate increases than a traditional approach? That by hyper-focusing and trying to make each person pay the premium commensurate with their individual risk profile, you have a wider variation in rate increases than if you were to rate at the pool level or by some broad rating classes?
Yeah, I think in general that's true, Brad. I think based on the experience in which in the way in which companies propose rate increases, that's true. Obviously, you could structure a cohort rate increase application with a wide variance in rates depending on how small the cohorts are. But to the extent that you're doing them seriatim, you're going to have a greater variance than by doing them on a cohort basis or a product basis.
And wouldn't that be a basis why some states have rules in place that require rate increases for long-term care to be on a class basis?
I'm not sure I can comment on that. I think there are many reasons states do that, and I'm not sure that that's the overriding reason.
You testified to this at the hearing. You would still agree, I assume, that the plan will not restore SHIP to solvency, correct?
Yeah, I think what I said at the hearing is that there's no guarantee that it will do so. And based on what I see so far in policyholder elections, I think you're probably right, Mr. Dorsey. We will not fully eliminate the deficit.
Well, actually, what you said was it was not likely we will magically restore SHIP to solvency.
I did say those words.
Yeah.
And I meant, I wasn't being private when I said that. I meant the plan has no secret sauce for eliminating a $1.2 billion deficit. We are doing the best we can under the circumstances, but that's a pretty big deficit.
I think we can all agree on that. Commissioner, I don't have any further questions.
I only have one, and you know, Brad, if you already have gotten into this and know this, you know, I don't mean to take us down a road that we don't need to go down, but I am interested in any analysis that you've made of what the potential lapses may be with regard to whether it's all of the policyholders or whether it's sort of focused on any particular geographic area or state, but whether you've looked at you know, what would be the likely lapse rate as these rate increases are implemented.
Well, so the plan deliberately has an anti-lapse component in it. Before the plan, a policyholder who stopped paying premium for the required length of time that is beyond the grace period would be deemed to have lapsed. But we won't allow that unless a policyholder deliberately makes a decision to lapse. So a policyholder who stops paying premium under the plan will automatically get the option 3, the NFO, and continue having coverage at no additional cost. We are, because we don't want to be, we don't want to impose our will. We are letting policyholders deliberately lapse if they really absolutely positively want to. But they have to make the affirmative decision, not just to stop paying premium, but to tell us they don't want the NFO. I don't have a projection of what the NFO take rate will be. at the end of the day, but it's 20% so far. That's probably, Commissioner Barron, as close as I can come to giving you a lapse rate, because we don't have a full lapse rate, a full lapse option available for policyholders.
Okay, thank you. I don't personally, I don't have anything else. I don't know if Van or Brad, Adam or Jeff, you have any other questions?
I don't have anything else. Thank you.
David, I don't know if you have any questions.
Yeah, I don't have anything further this time.
Okay, so
I'm
Mr.
good.
Go ahead. Okay, so Mr.
Yep.
Cantillo, I want to give you the opportunity if there are any final comments that you would like to make, or any other of the members of your team would like to be heard.
My only final comment is to thank you for the opportunity to address you and your staff. And we remain available to answer any questions that may occur after we finish this call. Dustin, Ginger, Allison, Gabriel, anything that I've overlooked that you think would be important for the commissioner to know?
Nothing for me.
So what I'd like to do now is, I think Mr. I will confirm that there is no one that signed up to testify at this hearing. And I have been monitoring the chat, but I do not see any indication that anyone has requested to speak. But what I will do is I will give any of the participants who are not panel members just a few seconds to put in the chat if they have comments that they wish to make. Again, I would note that this is an opportunity just to articulate your views. It is not an opportunity to ask questions of any of the members of the MIA or anyone who's here on behalf of SHIP. So let's just give people a few seconds to see if they want to take that opportunity. Okay, well, seeing none, then I will just point out that if you wish to provide a written statement, we will hold the record open through what date, Craig?
I'm not sure. Brad, do you know the date for the record?
February 15th?
Yeah, I'm not sure either, Craig.
That's okay. I'll make a decision right now until February 15th. So we will hold the record open through noon on February 15th. If anybody wishes to make any kind of a written statement, and you can submit that written statement by sending an email to, read it out, through the MIA's website.
The same place for pre-hearing comments for the hearing?
Correct. That's exactly right.
All right, thank you.
So, but just have them in by noon on the 15th if you want them to be considered.
Commissioner, the email is long-term care, all spelled out, one word, .mia@maryland.gov.
And Mr. Cantillo, as you said, we have to make a ruling by February 15th based on the plan that you sought the court to have approved and had approved.
That's correct. And would it be possible, Commissioner, for us to have a copy of the recording for this hearing?
It will be posted on our website, and we are happy to try to get it to you otherwise. But
Thank you very much.
it is public and it will be on our website.
That's good enough. Thank you.
And if you want, we have a mechanism to be able to convert through Zoom. I don't know how great it is, the transcription, but we do have the ability to pull some form of a transcription through Zoom.
Yes, we can.
Okay, well, I think that unless anybody has anything else, that would conclude today's hearing. So
Thank you.
hearing nothing, again, I will thank you, Mr. Cantillo, for your comments, your thoughtful responses, your thoroughness, your willingness to engage with us. I thank all the members of your team. I haven't been able to see Ms. Darrow on camera, but I've known her as well as you for a very long time. And there may be things that we will agree to disagree about with regard to this, and we'll see ultimately what where our analysis leads us and what our decision is. But in terms of, courtesy, thoroughness, your participation today is very much appreciated. So thank you for your
And the
professionalism.
very same from our perspective for your team and you, Commissioner Rain. We appreciate your professionalism and the attention you're paying to this important matter for us.
Thank you. And with that, the hearing is concluded. So thank you. I wish everybody well.
Thank you.